The first matter before the court is Penobscot 2437, State of Maine versus Scott Havens. Counsel appear to be present, and I assume ready to proceed. If you would identify yourselves by saying your names for the record, please, starting with the appellants.
Good morning. Rory McNamara for the appellant, Scott Havens.
Good morning. Chelsea Lynds for the state.
Thank you. We are, I believe, being streamed live on the web. We had a little technical difficulty to start this morning, but I think we have overcome that. And with that, counsel, we'd be happy to hear your argument. Attorney McNamara.
Thank you. May it please the court, counselor. If this court signs off on Section 358, the political branches of government will be free to exempt their favored parties and witnesses from offering direct examination. Trials will then consist of defendants attempting to rebut out-of-court presentations. It's no exaggeration to say that this portends a seismic shift in trials as we have always known them. This court will have then construed the Maine Confrontation Clause to offer no protection against the resulting sea changes. Face-to-face testimony, or if severe distress is likely to ensue, testimony at least within the presence of the defendant has always been required. Without it, several rights and assurances of reliability are eliminated. A defendant's own right to appear is diminished, as is the right to a public trial, because the most important part of trial would be a video recorded months or years prior and out of court. Unsworn quasi-testimony will be permitted. Fact finders will only be able to assess credibility to the extent the video recording permits it. The state's burden of production will be diminished. Defendants will be tried with guilt-suggestive technology. This court should hold that Section 358 violates the State Confrontation Clause, and I happily cede back any time and welcome any questions from the court.
And just to be clear, I know that the green light was on, but I also was aware that you had protected
I didn't even notice. Thank
2
you for doing
minutes.
that.
And I think we all knew that, which is why we didn't jump in. Oh, you don't have a remote for the light? Okay. All right. In any event, the green light now being on, can I move to the other issue, which is the specific unanimity?
Yes.
That was not preserved?
Correct.
Is that structural?
No, it's not a structural error, although as the court in the White decision said, that prong of harmlessness, so here it's a little bit different. We have the third prong of the obvious error test as opposed to the White decision was about harmlessness. But they both essentially go to substantial rights. Injury to substantial rights may be something more than just whether or not that outcome was affected or there's a reasonable probability of affecting that. And I have argued before that it is appropriate to hold in several decisions where there is a lack of a specific unanimity instruction. That is something that this court should automatically reverse for, because it is something I believe that the trial courts have seen decision after decision from, and it's still not being given. And I think it should be given as a matter of course. It's not a difficult instruction to give, and it's one that is appropriate.
So our jurisprudence has kind of created a tipping point, saying if counsel expressly waives it, then
Yeah.
it's gone, but if not, it isn't. And there may be circumstances where counsel might decide that they don't want them. Maybe they feel they've impeached the testimony completely. Don't want that. They want to focus right down on that issue, and they expressly waive it. But I'm asking you, is that a distinction that holds water, that us holding out to say, if there is an express waiver, then it's gone. But if not, if it simply is not given, then it is error. Is that a valid tipping point?
Yeah, and I do think there are two components to that. I think it would be one, foolish for any defense lawyer to say that I don't need a specific unanimity instruction. Other cases, other sorts of instructions, it may be perfectly within a strategy. I don't really see that with specific unanimity. It just doesn't seem to fit any strategy whatsoever. But yes, under this court's case law, under case law about waiver generally, an express waiver, meaning that instruction there, I'm declining that.
But if
That's
it's so
waiver.
well-known, I mean, presumably defense counsel, competent defense counsel would know, okay, we all agree this is multiple offenses taking place in a range, we need specific unanimity. If they don't ask for it, how is that not an implied waiver?
I think the same way it's not a waiver, well, lack of a waiver isn't the right term here maybe, but the same way it's not a.
It's a forfeiture.
Right.
This
we do-
waiver requires voluntary.
Thank
and
you, yes. And it is.
Why isn't it a forfeiture? Haven't we said in the past you've got to ask for it?
Oh, it's absolutely a forfeiture in the sense that we've forfeited the proper standard of review, a de novo standard of review. And that's the way I understand case law and the distinction between forfeiture. You're forfeiting a standard of review and waiver where that simply cannot be reviewed
Why
at
aren't
all.
you forfeiting you say, the judge says, anybody have a problem with these jury instructions? And everybody goes, no. Why isn't that a waiver or a forfeiture or whatever you want to call it?
Because there is so much that could go into instructions, that needs to go into instructions here, that can be missed. And it is not just the defense attorney's job to get all the instructions out there. It is, of course, that's the primary job of the judge, the trial judge, but it's also a job of the prosecutor to know whether this is something that's going to be appropriate and maybe trip you up on appeal. Now, of course, had there been a fully fleshed out discussion and we went through all the prongs of Alexander and counsel had said, that specific unanimity instruction there, I don't want that. But that's just not what we have here.
We seem to be in this limbo where the test now seems to be, well, it can be deemed unpreserved and we won't look at it if, from the record, it looks to us like it was a strategic choice. And so we're left in the position of going, could this be strategy or not strategy?
Mm-hmm.
And if the defense in a case isn't that it wasn't done on this day or that day, but it never happened at any time, then why is it obvious error that affects substantial rights?
Well, I'll take a step back. Where I started with Justice Meade was it's just not reasonable strategy ever for a defense lawyer. I'll say ever categorically.
Well, I think she moved on to a second issue, which is it harmless when the defense is, it never happened?
Oh, okay. Well,
And the
yes.
evidence is either it
Thank
happened
you.
100 times or it never happened at all, essentially.
Right, and the way I comprehend, the way I think about a specific unanimity instruction is perfectly congruent with a defense of it just never happened at all. And that is because at bottom, what it is asking jurors to do is to scrutinize cases like this where there's bare minimum and very generic allegations of abuse, and 10 counts of them, to go through and to really think, rather than a gut-level reaction to what we all have as the most probably serious and difficult type of cases where we tend to have gut-level reactions.
But are you saying, I just want to be clear about your argument, are you saying that it's up to the judge to give specific unanimity in every case where there's a range of offenses under one count, that the judge must do it, failure to do it is obvious error? Are you?
Yes.
Okay, all right.
I would say that. I would say that. Of course, you have to satisfy the prong. If this court is not going to go with structural error where we started
Right.
or some other remedy, then you do have to establish that third prong of the obvious error test.
So-
Absolutely.
So just, what do we do with the instruction that was given at the end, the re-instruction in response to the question, that basically time doesn't matter?
Right.
Should that instruction be given in these cases?
No, I don't think it should be given.
But it's
I
not
think-
an incorrect statement of the law, is it?
Except when there is ambiguity about whether or not it falls outside of the statute of limitations or within the
And that was the
element of
original
offense.
purpose of that instruction, is really a statute of limitations question.
Right, or the element of the offense here was under 12. So I don't think that that's presented here with these facts, but it is confusing, certainly in this
Did it
context.
aggravate the situation by giving that instruction?
It aggravated it, and it also, the requests for specificity, if you will, by the jurors indicate that they were perhaps wondering whether they really needed to identify discrete events for each of these. So I think that that is something, back to Justice Meade's question, back to Justice Connor's question, that indicates there is harm in this case, because jurors were wondering, do we have to be specific? What about these date ranges? And then they were told, no, essentially you don't need to worry about that detail.
Can I take you briefly to your Confrontation Clause argument?
Please.
I'm just looking through the jurisprudence and the scholarly writings and everything. There seems to be a consistent theme that the right to cross-examine sort of cures all ills that occurred, and there's really some strong language in the decisions. And Wigmore especially says, confrontation in its main aspect is merely another term for the test of cross-examination. The right of confrontation is the right to cross-examine. Confrontation offers a subordinate and incidental advantage, namely the observation. So he's saying, Confrontation Clause, you got cross-examination, you're good to go. The fact that you might not be able to, see is kind of sidelight. That's what the jurisprudence seems to say.
Yeah, I will agree that the federal jurisprudence, certainly since 2004 and the Crawford decision, seems to say that. And I think that's where Wigmore was going with that. There are multiple purposes, including federally. There have historically been multiple purposes, including a face-to-face
Well,
confrontation.
let's look at history, because that is an important part of when we have to go to ground zero and figure out what our Confrontation Clause means, correct?
It sure is.
Isn't it correct that at the time of the adoption of the Declaration of Rights, that the issue about child testimony was whether they could do an oath or not? And if the child was deemed competent, then they would come and testify. If the child was not deemed competent to take an oath, to understand the oath, routinely they would let in the hearsay statements of the child. And doesn't that indicate that it wasn't a constitutional issue?
So, first off, Your Honor, I'm not aware of any case law specific to Maine and specific to Section 6 that regards that, or more generally, with the Sixth Amendment or some other state analog of that.
Well,
I simply don't know
Crawford talks
that.
about it, and Crawford is about the common law, and there's a brief reference and a citation to the Indiana Law Journal that talks about this in some depth.
Oh, and one of the things, of course, is in 1820, there was a decision made in Maine to adopt a very specific provision that says, confronted by the individual.
And we got rid of the face-to-face from Massachusetts, correct?
Well, I don't know that we got rid of it. I think that
We did not
We didn't
adopt
take
it.
I think that it's fair to say, based off of this court's case law from the 1800s, that they understood confronted by the individuals to mean face-to-face. Certainly this court has said so many times in the 1800s. The point about, Your Honor made, though, about whether a child is deemed competent would require some kind of finding, some pretrial finding, that is simply not here on our facts as well. There is no finding that this individual in this case was not competent, and she was, in fact, if you watch the video, a pretty mature-looking child. I think it would be quite a leap to say that somebody like that is
think
not
he was turning it off.
competent.
I
I'm
saw
not
you
sure where we
glance, but no, finish your sentence. I didn't mean to.
I think I have finished my sentence. I'm certainly,
We're a little confused on our timer here. I think I'm going to start doing this when it's yellow.
okay, thank you. Just wave your hands, I will be quiet, I promise.
You've gone from digital to manual here, manual lights.
And where cross-examination was required, in many of these cases, there was also just an understanding that direct examination, meaningful direct examination was required. The technology that we have nowadays is something that finally has made saying so, in this case, necessary. 100 years ago, 200 years ago, simply not required. It was not necessary to say, no, you can't bring in a video recording of a witness.
Thank you, counsel.
Thank you.
Chief Justice Stanfill, and may it please the court. It was not error for the trial court not to give a specific unanimity instruction in this case. The victim in this case, who was only 10 years old at the time of trial, disclosed multiple forms of gross sexual assault and unlawful sexual contact that occurred multiple weekends per month over a period of more than a year. Although the victim did not describe every single instance, she described multiple specific acts and incidents. State versus Reynolds requires that a jury be properly instructed on the issue of specific unanimity when it is generated. Reynolds points back over and over to State versus Hanscom, which clearly states that on request, the jury should be instructed on specific unanimity, and references State versus Fortune, which says the same. There is nothing to suggest that it is obvious error, or even error at all, for a trial court not to step in and give a specific unanimity instruction sua sponte. In fact, that would likely be an overstep and could contravene legitimate trial strategy. In this case, the defendant, through his counsel, contended that none of these instances ever happened and tried to attack the victim as an over-sexualized youth with a motivation to lie about her strict grandfather. He affirmatively approved of the jury instructions that were given through his counsel. There is no obvious error, and to the extent that specific unanimity is an issue at all, it could be addressed in the post-conviction review process. Additionally, there were no overlapping dates in the indictment between the gross sexual assault and the unlawful sexual contacts. Turning to the issue of the confrontation clause and the admission of the Children's Advocacy Center interview, a state constitutional argument was not argued or developed at the trial level, but in any event, the state constitution and the state precedent doesn't require anything more than the federal constitution does. The Supreme Court and this court have recognized that the confrontation clause allows for the admission of certain hearsay statements. Title 16, Section 358 is consistent with similar laws being used and upheld across the country. In State versus Adams, this court said that when the declarant appears for cross-examination at trial, the confrontation clause places no constraints at all on the use of his prior testimonial statements. In this case, the victim took the stand. She testified on direct. She identified her abuser for the jury on direct. She testified that she was interviewed at an earlier date, and she clarified a few points, such as what she meant by the word private part in her earlier interview. And then she was subject to a robust cross-examination in which her truthfulness, inconsistencies, memory, character, and exposure to sexual material at 10 years old were attacked, and she answered every single question asked of her. The confrontation clause was not violated. Thank you. I'll take questions.
Counsel, you seem, going back to the specific unanimity issue, you seem to suggest that it wasn't even generated in this case. Is that what you were suggesting? Putting aside the issue of whether it was preserved.
I think that if it had been asked for, it probably would have been given, and I think that would be appropriate, but
Would it, if it had been asked for?
If it had been
Would it have
asked
been
for.
error not to have given it?
I don't know. It may have. I do think there's an argument that it's not generated because there was a range of dates alleged that did not overlap for the gross sexual assaults.
But then the jury was instructed that the dates don't matter. And so if they had been instructed that it had to happen during this range for this count and during this range for that count, that would be different. But that is contrary to what they were instructed.
Yes, I understand what you're saying. They were instructed that a date is not the essential element of the crime, and it's that the crime happened that matters. But I think that the concern for specific unanimity being that they identify some particular occasion, the fact that there is a range of dates that doesn't overlap cuts in favor of the state's perspective on
But
it.
isn't that the problem, that if you allow it to be any dates, and whether or not they were overlapping, and they were told it could be anything, and you don't give a specific unanimity instruction, isn't that, essentially going to end up being a likely violation of Article 1, Section 7, requiring unanimity in the conviction?
The instructions were an accurate representation of the law that the date is not an essential element of the crime.
I can understand your reluctance to take an affirmative position because, as we said in Russell, we reached the merits of his argument because on appeal, the state has taken an affirmative position conceding that specific unanimity was necessary, and that kicks the door open for review. So I'm guessing we're not going to get you to concede that it was required.
I would not concede
Okay,
that.
all right, understood.
Can I ask a confrontation question? Do you agree that under the statute about these interviews, that the interviewer is gathering testimonial statements?
Yes, I would say the statements are testimonial. They're likely to be used in prosecution.
And therefore, do you take the position that in Maine, we have adopted under our Constitution the testimonial test for confrontation announced in Crawford, which then rejected the old reliability test in Roberts?
Tell me if I'm not understanding your question correctly, but my understanding, and I think this answers the question, is that a witness needs to be available for cross-examination to alleviate any confrontation issue.
Well, I mean, in Roberts, and for a long time, the concept was in the federal courts that the concern, the purpose of confrontation was reliability. And hence, there are some Maine cases that talk about how reliability is the key, and some of them are cited by the defendant. But then, in Crawford, written by Justice Scalia, he says, no, it was all about whether something was a testimonial statement or not a testimonial statement. And is that change, does that mean we don't look at reliability anymore? Does that mean we've adopted that? How does that affect our review of those older Maine cases that the defendant cites?
Well, I don't know exactly how it would affect the older Maine cases, but in this case, I think it is a non-issue because reliability, one of the things that was talked about, I believe, in Crawford is that the ultimate test of reliability is to be subjected to cross-examination, which in this case, she was.
You're basically saying it doesn't matter which test we apply, the old Roberts test or the newer Crawford test, that this kind of situation where you are allowed to have some cross live would allay the concerns under both.
Yes, and particularly in this specific case where she did do a bit of a direct and then was subject to a lengthy cross-examination.
And the cross is not limited by the scope of the direct, correct? Under the statute, they're allowed to ask any question not limited by the scope of direct.
Correct.
Even if you took
And
a,
under the
even
Maine
if you
rules.
took a broader view of the concept of reliability and stretched it out to, include something like almost credibility, I mean, wouldn't testimony or statements that are given closer in time to the event and in a more relaxed environment be perhaps more reliable? I understand there's the whole cross-examination component of reliability, but I'm not talking about that. I'm just talking about purely from believability perspective. Wouldn't the statements closer in time to the event be more believable?
That is certainly the state's perspective. It's both closer in time, and if you look to the testimony that went into this bill, now law, there was testimony about how the CAC process is actually more reliable, and research suggests that it's more conducive to honesty and clarity by children than without the CAC and have them talk to potentially a caseworker, a police officer, a prosecutor. It is set up to be tailored to children's needs. And I would also just add that the statute requires that the questions be open questions, not leading questions. And the judge has to review the CAC and make a determination that the questions were not leading. And in fact, in this case, there were a couple of questions which got kept out by the judge because it's typical at the end of a CAC, whether it's generated or not. I think it comes from DHHS to ask if there were any photos taken or any images shown. And if, I think another question is about drugs and alcohol. And although she had not disclosed it in her initial disclosure, when asked that question, she had said that her grandfather had shown her pornography. And that was kept out because it wasn't something that was brought in by her. It was something that had been brought up by the interviewer. And so, yes, that was a long-winded way of saying, yes, the state certainly considers it to be more reliable, and I think there is research to support that.
Could we return just a moment to the specific unanimity issue? There seems to be something artificial about the fact about the state's role and whether the instruction is given or not given, whether they concede or whether they recommend it. And if everyone knows it's a fact, there's a bunch of events that took place within a range of time, but it's only alleged as one charge in the indictment, one count of the indictment, that would trigger, those facts alone would trigger the appropriateness of the instruction. And Attorney McNamara floated the concept that why would any defense attorney not request it? I'm just a bright line rule there. Are we focusing incorrectly on the state's role in this process? Should we simply be looking at the judge and looking at the facts of the case? Is it artificial to put sort of the burden on the state to say, yes, it's appropriate, yes, we request it, no, we're going to be quiet? Does it really make a difference what the state does?
Well, moving forward, I'll certainly explore it more, but I don't know that it's really the state's role to be opining on what jury instructions for the defense should or shouldn't be given.
But it is the state's role to ensure that constitutional rights are also met. And the Constitution requires that a verdict be unanimous.
Yes, but in this case, there really was no discussion about it because the defense was always that this never happened.
So if we set up that kind of dichotomy where the defense is it didn't happen, then are you suggesting then specific unanimity simply doesn't matter?
I wouldn't, take a stance that says it doesn't matter, but I do think that you can say it may be a legitimate trial strategy not to ask for it. I think it could be a legitimate trial strategy to have the opinion that a specific unanimity instruction could presuppose that this happened, and it's a question of do we know for sure when did the state,
I confess I'm a little bit on Mr. McNamara's page on that one. I cannot imagine why a defendant would affirmatively waive a specific unanimity.
And isn't it fair
instruction.
to assume that in almost every case, the defendant is going to say, I didn't do it?
Well, it may be. I mean, there are cases where the defendant doesn't say anything and the state just can't prove it for whatever reason. And there are other defenses, I suppose. But yes, your point is well taken. I mean, a lot of times they're going to say they didn't do it at all.
So what do we do with these cases where the charging instrument actually chooses a date range? It says count 1 between January 1st and December 30th of 2020. Count 2 is between January 1st and June 1st, 2021, et cetera. In other words, the state chose discrete ranges. But yet the jury is instructed that that doesn't matter. And, but they're also not told they have to unanimously agree on any particular incident. And for all we know, the jury thought it never happened in 2020 or whatever other period. I mean, what is the purpose of having even a date range if it just doesn't matter?
Well, for a crime like this, she had to be under 12. And the jury is also instructed that any inconsistencies, I don't know the exact language, but any inconsistencies about the dates alleged or uncertainty can be considered as to the strength of the state's
But why is the
case.
state even bother to put dates in other than just, under 12?
Well,
If it doesn't matter. I mean, that seems to be the position you're taking, is it just doesn't matter.
I'm not sure how else you would prove that someone was under 12 other than to allege a date. But I just don't think it's as plainly instructed.
Well, the victim
as-
testifies it happened when I was 10. I mean, that's how you do it.
Doesn't specific unanimity mean that the jury, all members of the jury, have to decide that the crime occurred on a specific date and a specific place?
It requires that they need to find beyond a reasonable doubt that the crime occurred on one specific occasion that they all agree is the same occasion. But the state would not have to prove it happened on June 1st, 2023.
Right.
So as long as everybody agreed that this crime occurred on a specific occasion that we all agree, then specific unanimity would be
Yeah.
satisfied, which I don't think departs that
Do we-
much from the instruction.
Do we know whether the jury agreed in that way?
Well, they found him guilty.
Thank you. Mr. McNamara, I believe you reserve some time for rebuttal.
I'll pick up with that question. I think we know that they probably didn't agree. They asked the question, the judge said, let's not be concerned about the dates, essentially. 4 minutes later, they came back with a verdict. I think it's pretty telling that that happened so quickly.
Would there be a problem if instead of instructing generally that date doesn't matter, as happened here, or sort of re-instructing that it didn't matter, if there hadn't been a specific unanimity instruction, but let's say they had said, you know, the date doesn't have to be specific, but you do have to agree on an incident between, for count one, that it happened essentially in 2020. And then in count two, you have to agree it happened in the first 6 months of 2021. Would that have taken care of?
I think what would have taken care of it is a specific occasion for each charge. I think, and I understand why we're talking about jury instructions here, but to answer the question about what do we do about those discrete charged time ranges, I think it's really incumbent upon the state to argue, to elect, to identify what specific allegation are we talking about when we're talking about each count. So that's less an instructional
You mean
issue
to
there.
specify in the indictment or in closing argument?
They can specify it in the closing argument, because
Okay.
you don't always know how the testimony is going to come out, but be able to identify these
Can I
counts
ask
are
about-
tied to that testimony.
One more side I want to talk to you about. The state said this waiver thing is a valid thing. If it's validly waived, then you don't get it. And if that's the case, that comes out in the post-conviction review. So is that a sufficient stopgap that if PCR came up later and during the testimony, the lawyer testifies, no, because of what we did here, I specifically didn't want that because I wanted the jury to focus down on the big picture. Absolutely, I waived it. Then isn't that a sufficient protection?
No, I don't
After the
think so.
fact.
And I don't think so because, again, it is not just the defense lawyer's duty to be offering this. And on the record we have, which the trial judge is charged with making, with getting everything on the record, with getting a charge conference on the record we have is, it just wasn't contemplated. And we've also talked, of course, about the strategy. There's just no reasonable strategy here that would fit that. The defense was, admittedly, it didn't happen. But the addition to that is, and we know that because it was such sparse, uneven, generic allegations. That's the way I understood that closing argument to be. And that is exactly why we're talking about the need for specific unanimity. Without that specificity, we're just saying there's maybe something there, but this is such a disgusting case, we don't want to get into the details.
Without specific unanimity, does it also run the risk of getting into a problem with double jeopardy?
It does. And we don't know what is coming out the other end of a juror's verdict. And I'm not sure if that's yellow or
It's actually red.
It's red.
But you can answer the question.
not colorblind. I think that is a potential problem. We don't know what a verdict means without A, the prosecutor electing, and B, a specific unanimity instruction. Thank you.
Thank you. Thank you, counsel, for the argument this morning. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. As is also our usual practice, Attorney Lynds, I understand this is your first argument, but for a high school argument in front of us, and so we would ask if counsel wished to come back and take the greetings of the court.